Good morning, everyone. We'll go ahead and get started. The time is now 9:01. Welcome to today's Board of Commissioners meeting this August 13th, 2024. I'm pleased today that we have Deputy O'Brien who will be bringing our pledge. In lieu of a minister today, we will be having a moment of silence. For those of you willing, please join us in our moment of silence. Thank you. You may now rise for the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Amen. Thank you. We'll now call this meeting to order. This morning, we have 3 presentations which will be brought before us today, and the first one is with respect to Child Support Awareness Month. If you are here with respect to this proclamation, I ask that you please join our commissioner down up front. Thank you.
Thanks, Brett. Good morning.
Good morning.
Oh, Rose is wearing green today. Everybody's wearing green today. I didn't get the memo. Can some of you guys just filter on this side? That would be great. That would be great. Wow, it's a lot. I don't want to cover anybody. Where's Rose? Okay. Okay, we're all here? Okay. Child Support Awareness Month emphasizes the importance of ensuring that all children have their basic needs met. The Cobb County District Attorney's Office, through its Child Support Services Division, plays a vital role in helping parents provide reliable support for their children. Working in partnership with the State of Georgia Department of Human Services and utilizing innovative resources like the Fatherhood Program, Parental Accountability Court, and a mobile app, the division assists parents in overcoming barriers to paying child support. The division has positively impacted over 6,874 children in Cobb County, handling thousands of cases and collecting millions in child support. Supported by a dedicated team of 17 employees, the Cobb County Board of Commissioners officially declares August 2024 as Child Support Awareness Month to continue promoting the health and well-being of all children. Congratulations. I don't want to cover anybody, but did you want to say?
Sure. I just want to thank the board for the support of the Child Support Division and thank you guys for all the work that you do. You bring in over $10 million a year into Georgia, helping our children be able to live the life that they can live so we can make sure Cobb continues to be the best place to live, work, and play. So thank you for all your hard work.
Thank you, and congratulations again. That's pretty impressive. Okay. Any more photos? No? Okay. We're good. Okay.
Okay, thank you. Our next presentation will be to recognize our information services for being ranked with respect to the Digital Counties Nationwide Survey. For those of you who are part of this presentation, please join us up front.
Thank you, Chairwoman. It is with great pleasure that I ask the ITS Service Department to come up and be recognized as being ranked 5th among the top 10 digital counties nationwide, serving a population of 500,000 to 999,000. So if Kim and her team would come forward. Thank you.
Oh, wow. The whole team. And it is a team that makes us happy. Oh, just half. Now, we typically don't see you on a day-to-day basis, but you are that voice of reason that many of us interact with as we are trying to move our offices forward when it comes to technology, especially with some of us being more or less adept than others. So thank you for any of you that I have interacted with, and thank you for maintaining all the many systems that you do in our county. A little bit about this survey. The survey is in partnership with the National Association of County Officials, and it identifies the best technology practices among U.S. counties, including initiatives that streamline delivery of government services, provide data analytics to allow decisions based on performance and outcomes, and enhance cybersecurity and apply innovative and emerging technologies to county priorities. This is quite a competitive survey that is applied nationally. Have we moved up the ranks a little bit? Yeah, so we just keep getting better and better in demonstrating to providers nationwide about the strength that we have here when it comes to IT services here in the county. So it was a pleasure to be with Kimberly as she received this award. I'm going to pass this to you so you can highlight your team's work.
Thank you so much, Chairwoman, County Manager, Board of Commissioners, our agency director, Sharon Stanley, and all the departments that we partner with to make our county a better place using technology. This team has done amazing work over the last year. I'm so proud of what we've done to enhance our technology infrastructure, constantly improving our cybersecurity posture, and making our services more available to you as citizens online. So I'm so proud of everyone and everybody in the department. This is only probably about half our department, but everybody has had a role in this journey over the past year of all the accomplishments that we've had. So I'm so proud of everyone, and thank you all.
I thought it was me. Damn, thank you. Sounds like a heart. Finally, I'll see, is anyone here for this third presentation with respect to Whataburger Day? Yes, please join me up front. So thank you for being here today and for giving us the opportunity to recognize you and establishing your, 1,000th restaurant here in Cobb County. And this chain debuted in 1950 in Texas, and you have been able to spread nationally the home-based burger, yes, that has brought a lot of jobs to communities all throughout our nation, but certainly here in Georgia. I understand your chain employs roughly 50,000 people, and we recognize you being famous for your customizable burgers. But we also thank you for your contribution to our community as well, as you recognize there are those that you can help support with your business model. So therefore, we, the Board of Commissioners, want to recognize and congratulate you on over 70 years of success. Not many of us, even as individuals, get to make it to that number, let alone a business here. And we proclaim August 8th, the date of its founding, a Whataburger Day in Cobb County. This the 13th day of August 2024. So congratulations to both of you. If you could let us know who you are.
My name is Cody. I am the operating partner of the Whataburger on Barrett Parkway.
Also, my name is Andrew Tillis. I'm the operating partner on Kenneth on Chastain, 1320.
We appreciate you being here. Thank you so much. Yes. This is for you?
I'm sorry.
Oh, man.
That wasn't
Next
on the
time.
agenda.
All right, thank you so much. Appreciate it, gentlemen. Okay, we are now at the public hearing portion of our meeting. We had two public hearings that were originally on the schedule, but the first one has been withdrawn by staff. That was with respect to Bentley Lake Road, as I believe there's more work that needs to be done on that matter. So we are now at our second public hearing, which is to conduct our first public hearing to solicit comments and input on the proposed amendment to Chapter 78, which is for licenses, permits, and businesses.
Good morning, everyone. Jessica Gwynn, Cobb County Community Development Agency Director. This morning, we do have a code amendment that's being brought forward for the first public hearing. This is to Chapter 78 licenses, permits, and businesses, specific to peddlers, door-to-door salespersons, and mobile food vendors. This is actually a code that the board adopted in 2021 pertaining to the Major League Baseball All-Star Game. It establishes a clear zone and determines what types of activities can occur within those event areas pertaining to your folks who may be doing peddling, may have those sorts of licenses. Also speaks to temporary signage and those sorts of things that will be necessary for the All-Star Game. When the code was adopted in 2021, of course, it was specific to the dates of the 2021 All-Star Game, which of course did not happen in Cobb County. We are very excited that that's coming back to the county next year in 2025. So all this amendment does is just to change the dates to reflect the 2025 All-Star Game rather than the 2021 game. Glad to answer any questions, and otherwise would ask the chairwoman to open the public hearing.
Thank you. We'll open up the public hearing, and then I'll let commissioners ask any questions following that hearing. For any of our attendees, you are able to speak to this chapter and this chapter only, and this is again with respect to licenses, permits, and businesses for the 2025 Major League Baseball All-Star Game. We'll take an unlimited number of speakers to address this matter, and you'll have a total of 3 minutes to do so. Just ask if you have not been to our meeting before to know that you need to state your name prior to providing your comments. So with that, we'll open up our hearing, and we'll begin with our first speaker.
Thank you, Madam Chair. For the record, James Bally here on behalf of the Atlanta Braves. We do have a matter before you today that you had in front of you in 21 when we were lucky enough to be selected to host, and we're back in 25, and so we would ask that you adopt this minor cleanup that just changes the dates to match the new 2025 All-Star Game, which we're excited to host in 25. So here to answer any questions you may have, but other than that, that's all we have. Thank you.
Thank you. Appreciate it. Are there any other speakers with respect to this matter and this matter only?
Good morning, Holly Quinlan, Cobb Travel and Tourism President and CEO. Cobb Travel and Tourism appreciates the county's consideration of the proposed code amendments and supports the county's efforts to coordinate with Major League Baseball to allow the county and the Atlanta Braves to host the All-Star Game in 2025. This is a major hospitality and tourism event that will again put Cobb County on the national and international stage. So we appreciate your consideration of changing the date to support this effort.
Thank you. Are there any other speakers with respect to this matter?
Hill, right? I just want to make sure there is no changes that would in any way hamper the public's ability to protest or express freely their views. Thank you.
Okay, thank you. Are there any other speakers?
Give me 10 cents, not 2. Donald Barth. Good morning. Ladies, we can't get any better in Cobb County than to have an all-star game in our own county. Not to mention 2025, we're going to have some World Cup activity up here. I mean, do you see how big that is for the county, the revenue it's going to bring in, the hotels, the motels, the food, the jobs? So whatever you can do to make this work for the county, do it. Do it. What negative can there be in having this kind of exposure to the world? So do what you got to do. Thank you.
Thank you. Are there any other speakers? Okay, not seeing any, we'll close the hearing. Jessica, if you can approach. Yes, and we'll see if commissioners have any questions. Yes, we'll start. Go ahead, Commissioner Burrow.
Not really questions, but I know this was approved in 2021 previously, and we're changing the dates. But it's my understanding that this is coming from MLB, not necessarily the Braves. This is an MLB, Major League Baseball requirement or request.
This is something that we need to do to satisfy the Major League Baseball requirements. Yes, as I understand it, this is a code that's typically adopted by each host city prior to the event. Yes, ma'am.
Thank you.
Okay, are there any other comments or questions from commissioners? Again, there was a comment with respect to enabling protesting. Yes, is that affected by this ordinance?
No, there is nothing in this code at all that speaks to to the ability of individuals to gather or to assemble or to speak their minds.
Okay, thank you.
Okay.
Thank you, Jessica, appreciate it. I don't believe there are any other questions. This is the first hearing out of how many?
The next public hearing and the final public hearing will be on August 27th at the regularly scheduled meeting at 7 o'clock, and that will be the board's opportunity to vote on the amendment.
Okay, thank you so much.
Thank you.
With that, we are now at our first public comment, and I'll turn things over to you, Bill.
Thank you, Chairwoman. As the board provides the podium for public comment, it's appropriate to review the related meeting rules. Please state your name and if you're speaking on behalf of an organization. All comments should be made to the commission as a body and addressed through the chair. Public comment is not a dialogue with the board, but an opportunity for speakers to provide their comments to the board. Comments should not be slanderous. The board encourages, regardless of the topic, for the audience to be respectful and courteous to all speakers. Everyone attending this meeting should give others the right to both listen and to be heard by each other. Statements made during the public comments portion do not necessarily reflect the opinions of the board or the administration of Cobb County government. There is a timer on the podium for you to be able to keep track of your time. The first public speaker is Hill Wright.
Hill Wright. Madam Chair, today's proclamation of Whataburger Day is a day not for the people, but for pandering, promoting private business interest. Nowhere in the Commissioner's Rule of Procedures as amended on March 26, 2024, does it permit the promotion of individual businesses, only county residents and nonprofits. This blatant disregard for the fairness should have been removed from the agenda. I expect to see a day proclaimed for every small business, starting with the Mega Hats business to have Mega Hats Day. After all, if we're opening this can of worms, why stop at burgers? In October 2022, I warned you against drawing your own maps, urging you to seek a fair solution to keep Commissioner Richardson on the board without violating the law. Yet you ignored the advice, and not one but two judges has now ruled that these maps are unconstitutional. Chair Cupid, you crossed the dangerous line with this illegal lawfare, one that reeks of election interference and attempt to handpick candidates. It also reeks of this board colluding with the elections board to allow you to stall the latest ruling, trying to run out the clock. The actions by both boards should embarrass pond scum. You claim that failing to adopt your maps would force Commissioner Richardson to step down on January 1st, 2023. But the truth is out. Your scheme to overturn the Georgia Constitution has failed, and Commissioner Richardson's presence on the dais is now unlawful. Last week, you held an improper executive session, sidestepping the necessary public meeting. This is just improper. It's a violation of the public trust. What you've hidden from the public scrutiny is your continued defiance of the judge's order, running out the clock in hopes of avoiding new elections. Let me be clear, we the people will not stand for this. If you persist in this lawfare, we will call for mass protest, a march for democracy, drawing citizens from all across Georgia to Cobb County to protest your Constitution, protect our Constitution. You may try to intimidate us with scores of officers at your event, but let me assure you, Madam Chair, that no amount of law enforcement will silence the people's voice. We will be peaceful and lawful, but relentless. At every campaign and event where taxpayer dollars are wasted on pandering, we will be there to make sure people know the truth about your actions. Chair Cupid, it's time to stop the charade, or we will stop it for you, by the thousands, by the power of the people. And remember, Madam Chair, when you serve up Whataburger Day, we're here to serve up What a Protest Day. Let's see which one leaves a better taste in the mouth of democracy.
Virginia Choate.
Virginia Choate. Taxes, taxes, and more taxes. 30-year taxes. Chair, your devastating policies will not only kill this suburban county, but also the very people that you say you support will be hanging on by their fingernails. Next subject. Chair, interfering in our elections, wow. With these illegal maps, it is very clear that Ms. Richardson should not be on the dais. Chair, I just wanted you to know that Commissioner Richardson should not be sitting here. You are operating illegally.
Susan Strevens.
Good morning. I'm Susan Strevens, and I bless you all, but I also have some things I'd like to say. I have notices, and I'll be giving it to putting it on the record. And first, I'd like to talk about the notice to public servants of mail administration for restricting the people's freedom of speech to redress grievances. 3 minutes. Actually, it's not public comments. I'm here to redress grievances, and I use the Constitution, which is the highest law of the land in the state of Georgia. And so I would like to have that addressed, that we have our grievances addressed and it not be squashed into 3 minutes, which really doesn't allow any kind of real discussion. So I'd like a meeting for us to be able to do that. It is one of the fundamental rights that you swore an oath to protect, is our freedom of speech. And the other thing I'd like to talk about in regard to the home rule is that it was found unconstitutional. Therefore, those who voted for it, you have broken your oath of office. And therefore, you've actually removed yourselves from your position because you have broken the oath that you took, which is a trust indenture contract to serve the people. And and you have violated that. In addition to that, I wasn't able to speak at the election meeting yesterday, but I also have that notice that I want you to all have, because the elections are not run lawfully. Voting machines cannot take an oath to be held accountable. And you go to the original Constitution, and it talks about it being conducted by we the people and not third-party vendors and such that have no accountability or take an oath. And the other thing was the certification thing. How bizarre is it to certify the election for the sake of certifying it versus really knowing that it was properly conducted and that my vote counted? So thank you for those things to ponder, and bless you. God keep you in Jesus' name. Amen.
Donald Barth.
Donald Barth. I want to say one good thing about Cobb County. Recently, we had the Nights Out, National Nights Out, a community event, wonderful. Understand some of you I ran into. I know that Cobb County has spread out now, so other cities, the county is not holding it, making people come on one night to one place when they have to go to school and work. Now that we got the pleasantries out of the way, bam, 800,000 people in Cobb County, and you can't get somebody up here to pray? What the hell does that say about you? Hell, look down there. See that man with the collar on? He's advertising. You really don't care, do you? I'm going to say minutes of silence versus grant me the serenity to know what I can change the things I can, and the wisdom to know when I can't change you. You understand where I'm coming from? How do we get through your skull? You're the one that sat out there in the lobby a week ago and told me I couldn't go to a public meeting. I tell you, bullshit. Plain out. Do you hear me? You can't do anything about it. A public meeting is a public meeting. You're a lawyer. Robert's Rules of Order should have been there. You should have known how to conduct the meeting. There was so much wrong with that meeting. You'll know about it in the end. You cannot keep doing what you want to do with your minions. This is our county. You work for us. You were elected by the people to serve the people. You don't serve anything except yourself and whoever your puppet master is. Now, we talk about an election, a fair election. How in the hell can you have a fair election when you're over there shuffling? You can't shuffle the cards at will. Oh, you got away with it for the time being. You have broken the Georgia Constitution. You broke your oath. So it tells me right now, you don't give a damn about your own words. You give a damn about what you want. How can she sit on the dais when it clearly states in Cobb County law that she cannot? The enabling legislation could have been fixed. 5 people could have got together and fixed an enabling. We're not going to fix the damn thing. We're going to do what we want because I'm Lisa Cupid. You ain't squat, lady. You're out of control is what you are.
Mr. Barth, your time's up. The next public speaker is Christine Rosman.
Good morning, Commissioners. Christine Rosman, And I would like to also address the home rule issue. We have a majority of 3 commissioners that like to usurp the Constitution, Georgia Constitution. Constitution deniers, I guess that would make you all. But you're also causing election interference. I'm sure there are plenty of people out here, because I know I talk to people all the time, no clue what district am I in? Who's my commissioner? Because they don't know. Because you get a different story from the Secretary of State, you get a different story from Cobb's elections. So anyway, there are secret meetings going on. You try to overrule, overrule what a judge is ruling on, and then grossly squandering the taxpayer dollars to do all of this. And if you say, oh, we just have, attorneys and we can use them at will, what are they not doing because they're so trying to figure out this thing about home rule? Okay, the last meeting, you had people from both sides come up here and talk to you about what they want. You're not listening to us. Your actions speak so loudly, we can't hear all the niceties that you're saying to us and trying to placate. You all took an oath, but you're tone deaf to your oath, you're tone deaf to your constituents. Thomas Sowell, love the man. It is usually futile to try to talk facts and analysis to people who are enjoying a sense of moral superiority in their ignorance. That's what sometimes it feels like talking to a majority of the commissioners. Hannah Arendt, A-R-E-N-D-T, Arendt, she's a German historian and philosopher. She says the constant lying is not aimed at making the people believe a lie, but at ensuring that no one believes anything anymore. A people that can no longer distinguish between right and wrong. And such a people, deprived of the power of thinking.
Ms. Rosman, your 2 minutes are up. The next public speaker is Tracy Stevenson.
I was going backwards now. Okay. All right. Thank you.
Good morning, Tracy Stevenson. I also want to speak about the maps. It's another day, another attempt to delay the inevitable with respect to the constitutionality of the unconstitutional home rule maps. You have filed yet another motion to ask for a definitive answer on whether the home rule map generated by Cobb County is unconstitutional. This was asked and answered yes by Judge Harris, yes by Judge Hill, and circuitously yes by the Georgia Supreme Court, even though the Floam suit was tossed on a technicality based on standing, not on merit. Like a petulant child, you keep asking the parent the same doggone question, trying to get a different answer, and it's not coming. Judge Hill declared the home rule map was unconstitutional in order to stay of the general election for districts 2 and 4 and to hold a special primaries as soon as possible. Yet your motion of intervention seeks clarity, which has already been provided in Judge Hill's ruling, that it found unconstitutional to definitively order the BOE to invalidate the 521 primaries and schedule new primary elections. In this suit, you filed amicus briefs, which work on the same principles as your motion of intervention. Why? This has been asked and answered 3 times now. Did you file the request for intervention just to try and give the county appeal rights since you are not a named party? It certainly appears that way. Without this filing, since Cobb County was not named, you had no appeal rights. Didn't you already file those amicus briefs and raise these exact points, which were essentially set aside by Judge Hill? I heard that no means no. I can only posit one purpose for this. It's to delay the process. Mr. White and the BOE have previously publicly stated on the record in the MDJ that they would accept Judge Hill's orders and not appeal, but their actions speak louder than words, as they have appealed. Why does this lawfare continue when this has been asked and answered, and the resounding answer is yes? Your home rule maps are unconstitutional. I would say the same thing no matter who drew the maps, Republicans or Democrats, because I'm a constitutionalist guy. I'm a constitutional guy. Why, how many taxpayer dollars will you continue to waste? Have you no conscience, no honor? I think neither. We the people demand both from our county officials, whether they be elected, appointed, or hired. Thank you for your time.
Thank you.
Jeff Jones.
Good morning, and thank you for the opportunity to speak here. My name is Jeff Jones. I live in Smyrna. I'm here to advocate for MSPLOS funding, and I am grateful that it is on the November ballot. I ride the bus as often as possible. I got here this morning by bus, and I will get home by bus. Quality bus service is crucial for Cobb County. I'm pleased that the buses run on time and that the drivers are friendly and helpful. I would love it if the buses ran more frequently, if they operated more efficiently, and they went to more locations. MSPLOS addresses each of these. I'm sure you've heard many good reasons to support MSPLOS. This morning, I want to tell you about the people I ride the bus with. I ride the bus with hospital and university employees. I ride the bus with employees of a middle school and a senior living center near my home. I ride the bus with an elderly gentleman who has a brain injury and is not able to drive. I ride the bus with employees of restaurants and a thrift store. I ride the bus with two young men who have neurological challenges and who are able to be more independent because of the bus system. I ride the bus with teenagers who don't have a car, probably don't have a car or a driver's license. For a while, I rode the bus with a man whose truck was being repaired. And of course, I ride the bus with hundreds, if not thousands, of others. I've told you all of this because I want you to know how important Cobb Link service is. Cobb residents love their cars, but not everyone can afford one. AAA estimates that the average yearly cost to own and operate a vehicle in 2022 was $10,728. Not everyone can afford that. I want to live in a community where citizens who cannot afford a car are valued citizens. High-quality public transportation is a vital part of that. As I mentioned, some Cobb residents cannot drive cars. It warms my heart to have a bus system that says we care about you. We celebrate your ability to be independent. As I mentioned, Cobb Link service could be improved upon. Sometimes I drive because there is no bus service to the places I want to go in Cobb County. Once, I decided to walk home rather than wait an hour for the next bus. Buses that run more often, operate more efficiently, and go to more places. That's what MSPLOS will do. I'm grateful for the opportunity to speak to you this morning.
Sally Grubbs.
Good morning, Commissioners. My name is Sally Grubbs, and I'm the chairwoman of the Cobb County Republican Party, but I'm here this morning as a citizen. When I was trying to decide what I wanted to say about the fact that we have 3 commissioners sitting on the dais who have violated their oaths of office And there have now been judgments come down saying that you are illegitimate in your seats because it was an unconstitutional process by what you did. I kind of think, why should I waste my time speaking to you? But the fact is that you're sitting in a seat paid for by the taxpayers of Cobb County, and you think that you can rule over the citizens with great abandon and without accountability. And whether it's today or tomorrow in the next 6 months or what have you, there will be accountability at some point. And if to no one else but God, you're going to be accountable for sitting in seats that you violated the oaths to get there. On another note, I was texted on the way here with the, Cobb County in all its glory and wisdom has made the front page of the New York Times with our election director, Tate Fall. The article says, Tate Fall is overwhelmed. When she signed on to be the director of elections in Cobb County last year, she knew she'd be registering voters and recruiting poll workers, maybe fixing up voting machines. I don't really know exactly what that's supposed to mean, but that's what the article says. She didn't expect the unending flood of disinformation, or at least she wasn't prepared for how much it would overtake her job. The disinformation has come from this board. She's going to come up here and request funding for $2.5 million from the taxpayers of Cobb County for a mess that you have created. Now, the blame is being put on election deniers, and the blame is being put on having to actually answer questions. I didn't know it was such a stress to ask questions about things when they have incorrect maps posted on the Board of Elections website, and I call attention to that. I didn't know that was a big deal. But with the chaos you people have created, now you're going to make the taxpayers pay for that when it's your responsibility and it's your quest for power over Cobb County that has caused this situation. Mr. Rawling and the legal department, these attorneys working, I guess, maybe in conjunction with the Board of Elections, are causing hundreds of thousands of dollars to be spent by private citizens in addition to the taxes because you refuse to acknowledge the fact that you violated your oath and Ms. Richardson should not be sitting on the dais. And you have protected her at all costs in that seat so that you can have the majority. And it's wrong.
Ms. Grubb,
and
your
it's
time's
time.
up. The next speaker is Derek Blassingame.
Thank you for the opportunity to address this body today. My name is Derek Blassingame. It was because of me, Derek Blassingame, that we are here today, more vibrant, more free, and more diligent. It was because of my life and my mind that this commission is led by all women, and it is I who gave you Hillary Clinton, Condoleezza Rice, Michelle Obama, and now Kamala Harris. When I came out to Must Ministries, an agency that Cobb County, Georgia, and federal taxpayers have invested millions of dollars to rebuild, on August the 6th, I traveled from the city of Atlanta and downtown, homeless, helpless, but with a lot of hope. Instead, I was accosted by the city of Marietta police. Instead, I was issued a criminal trespassing warning citation and told not to return to the property for 5 years by Must Ministries' head of security. Keep in mind, I waited in line outside of their gated fortress, and I was invited inside of their property. I was publicly humiliated, embarrassed, deprived of water, shelter, clothing, access to federally funded programs for homeless, unhoused, and struggling citizens. All because I asked the question, what type of services do you provide homeless individuals? I am not a victim. I am victorious. Because despite it all, I am present today. Let's keep in mind that it was I who Must Ministries built and manifested its recent vision and mission upon. Must Ministries is a religious cult that deprives our less fortunate of their identities, strips them of their rights, and uses law enforcement to force its clients to conform and comply with their religious Jim Jones-style dogma, all funded by the Cobb County government and evidenced by their very actions towards me on August the 6th. Even today, I was accosted by the Cobb County Sheriff's Office from accessing this public meeting to put my grievances on the record. To the commission, when I entered the chambers, I overheard District 1, District 4, and the chairwoman called me crazy, suggested that I was under the influence of some type of boogeyman. Let me set the record straight. I am here by my own free will. I have a clear conscience and a mentally stable mind. I do not have any mental illnesses as evaluated by 3 psychiatrists. I recently finished all course requirements to graduate from the Georgia State University. I currently have a 4.0 GPA at Gwinnett Technical College. I want to remind this government that you have been created to protect the governed and not the governing. Let me speak to those in the room who may not understand this language. The scripture teaches us that whatever you did to one of the least of these brothers and sisters of mine, you did for me. That's what Jesus declared to the people. And further, finally, Congress, this body, shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. I respectfully request that you all investigate Must Ministries immediately.
Chairwoman, this is the final public speaker.
Okay, thank you. With that, we will now move on to our consent agenda. The matters on consent have been scrolling for the public to see and on the screen for those of you viewing remotely, and will do so at the end of this meeting. Before we do have a vote on consent, I move that we add as a non-agenda item to approve an exception to our parental leave policy. Is there a second?
Second.
Any further discussion? Yes, Commissioner Burrow.
Madam Chair, before we vote, I would like to read my revised statement.
Okay.
For the record. Considering the Supreme Court's ruling in January regarding standing on the home rule issue, my position regarding the home rule challenge still stands. I did not support the home rule challenge of the majority of this board. It is unconstitutional and illegal. I voted against the amended map 3 times in 2022, January 25th, October 11th, and October 25th. I have a duty to represent my constituents and will not have my vote suppressed as I was duly elected on November 8th, 2022 under the state map, House Bill 1154, voted on by the General Assembly in February 2022 and signed into law by Governor Kemp on March 2nd, 2022, and certified by the Cobb Board of Elections on November 15th, 2022. In addition, I do support the order on cross motions from summary judgment, civil action file number 23-1-02428-56 from Judge Ann B. Harris in the Superior Court of Cobb County, dated January 8th, 2024, which finds the county's amendment to Act 562 is an act excluded from the county's home rule authority granted in the Georgia Constitution and therefore is void. Although the Supreme Court of Georgia only ruled on standing and did not rule on the merits of the case, I concur with Justice Bethel's remarks regarding home rule authority. With respect to Judge Hill's order dated 7/25/24, I also support her order and do not support the county's request to intervene or request for reconsideration of her decision regarding the Alicia Adams versus Cobb Board of Elections case. I did not support the majority of this board regarding the home rule challenge from the very beginning. It has gone on for the past 2 years at taxpayers' expense and should never have been done to begin with. We all took an oath to uphold the Constitution of the United States, the state of Georgia, and Cobb County. Follow the law.
Yes, Commissioner Gamble.
I too have a new statement to read into the record. Since March of 2022, the board chair, with the support of her identifying party, have requested the county legal department not to follow the law, but rather to circumvent it. The majority initially claimed we had the legal authority under home rule to draw our own district maps rather than adhere to the statutory state legislative map. This board has had many opportunities to accept the rulings of several judges and other legal authorities and accept that the actions taken by the majority were unconstitutional. But to date, have preferred to follow the path of anarchy and ignore those rulings and opinions. Numerous cases have been cited where the Georgia Supreme Court and federal courts in Georgia have ruled the General Assembly is the only legislative body with the power to enact redistricting legislation for the county. Prior to the resolution being passed on October 25th of 2022, the county received a letter from Stuart Morelli, Deputy Legislative Counsel for the General Assembly of Georgia, to Representative Setzler, who requested an opinion from their office as to the ability of the Cobb County Board of Commissioners to use either its constitutional home rule powers or statutory authority to approve a new district plan for the board. As explained in this letter, it appears that county governing authorities do not have the constitutional or statutory home rule redistricting powers. Again, on December 22nd of 2022, a letter from Ryan Germany, General Counsel for the Office of the Secretary of State, quote, "You should not consider the ministerial function of filing an amendment with our office or the publishing of the amendment is allowable under state law or a proper exercise of the authority of the Cobb County Commission, nor should you rely on this to attempt to establish the validity of the amendment. In fact," he continues, "it appears that the amendment is very likely an unauthorized exercise of authority by the Cobb County Commission that does not comply to Georgia law or the state constitution." Several legal challenges were put forth, and instead of accepting Judge Harris's ruling on January 8th of 2024, the county appealed her ruling within hours. Interestingly enough, the Board of Elections never challenged standing, as they wanted clarity and were willing to accept the judge's opinion. While the Supreme Court was not able to rule on the merits of the case due to declaratory judgment, their ruling on May 9th of 2024, Justice Peterson wrote, quote, "The entire dispute in this case is about the public duty. In enacting Act 562, the General Assembly set the electoral district lines for Cobb County. Although the parties dispute whether Cobb County had the authority to revise those district lines, it could only do so if the home rule paragraph allowed. Whether this case is framed as a duty to follow Act 562 or a requirement to follow the home rule paragraph, in either case, the heart of the case concerns Cobb County's duty to follow the law. This is sufficient to confer standing for the Floam challenge to the Board of Commissioners amendment." The very last sentence then reads, "We express no view about the correct resolution of the very serious constitutional issues with the Board of Commissioners amendment." Justice Bethel concurred with the following statement, "But litigation takes time, and it is easily within the realm of possibility that several months could pass before such litigation is concluded, particularly if Cobb continues to pursue what could be interpreted as a deliberately leisurely litigation strategy." He then warned of citizens without duly elected representation, and to avoid these possibilities, it seemed to him that Cobb has an interest in reaching a merits-based resolution as quickly as possible and urged Cobb to act with all due haste in securing finality. Yet the legal department continues to advise the board to take measures to circumvent finality, and the board's majority continues to follow a legally questionable path. As an elected official of Cobb County, I took an oath of office to uphold the Constitution of the United States and Georgia, uphold the laws of the state and our local enabling legislation. I clearly understand our enabling legislation, Section 223B, and OCGA 4551A5 and B, and in my opinion, the majority of the board have demonstrated a willingness to ignore the law, and in doing so has pivoted from making administrative decisions to practicing malfeasance. Per Deshauna Stokes, quote, "Leadership by deception isn't leadership, it's fraud. Truth is hard, propaganda is cheap."
Thank you.
I recognize the statement of both commissioners. This has been a matter that we've been dealing with at length, and we know that each one of us on this board has a duty to uphold the Constitution. We recognize the challenge that was asserted by the state in circumventing the practice of adopting the maps of our local delegation. The steps that our board has taken has been to assert what we perceived we were lawfully able to do under the Constitution of this state, and we did not do it independently, but with the advisement of counsel in seeking how we moved forward. We understood this entire time that this was a question of law, but that is what the courts are for, to settle those questions of law. And it went through that process. A lot of the statements that have been referred to are also dicta as part of the Supreme Court ruling, which means that it is not part of the judgment, even though it is informative and advisory as to how a judge views a ruling. That ruling or that dicta of the court, however, does not hold authority in the matter because, as you stated, there was not standing by the plaintiff. Subsequent to that, there was a local lawsuit that was filed, of which we are still seeking clarity on. There has been no effort to circumvent the Constitution. However, there has been an effort to circumvent the many voters that did vote for each one of us that are sitting here today. There has been an effort to circumvent the reliance that has typically been on trusting the local elected delegation in applying, putting forward a map that governs the Board of Commissioners. That has been the process that I have seen over the 12 years that I've been here, but there has been very little objection or question about why that was circumvented. I think this is not a discussion with anyone here in the audience. In fact, if you want to have a conversation, you can step out and do it in the hallway. At this time, I can understand why there is concern with respect to Commissioner Richardson. We also have concern as to how we move forward, which is why there has been additional steps taken to get clarity from the judge and how we move forward. We will work together to do what we perceive is best in the interest of all of Cobb County citizens, and we know that there will come a finality to this at some point. But I want to recognize that a great harm was done. A great harm was done to our county that we have to question when the state does not consider what comes out of our local delegation with respect to what happens in your local organization, here being the Board of Commissioners. With that, Commissioners, we are still on the consent agenda. We are adding a motion, which is a non-agenda item. It needs a 4/5 vote to be added. I believe there was a second, so I'll go ahead and call the question. The motion carries 5-0. Commissioners, I believe there has been a revised attachment to Animal Services Agenda Item 27. I have a copy up here. I'm looking to see the revision. Excuse me, for our clerk, can you help me understand what the revision is here? I have the document, but I'm not seeing any red line. Second page, thank you. Okay. Okay, thank you. So there was just some information missing. That's now available. Need to just look through this and make sure there are not other revisions I need to recognize.
I'm sorry, what number was that?
Agenda item 27.
They had sent an email to us yesterday stating that the page had been omitted.
Thank you for clarifying. Okay, are there any other questions? Okay, so with that, Commissioners, I move that we approve the matters that are on the consent agenda as they have been revised and to authorize execution of the necessary documents by the appropriate county personnel.
Second.
Are there any comments or questions? Yes, Commissioner.
Yes, Madam Chair, I am in opposition to number 33.
Okay, one moment. Okay, number 33 is respect to capital funding. Okay, are there any other comments or questions? Yes, Commissioner Campbell.
I am also opposed to agenda item number 33.
Okay. Are there any other comments or questions? We'll go ahead and call the question in recognition of Commissioners Burrow and Gamble's opposition to 33. Okay, the motion carries 5-0. Thank you, Commissioners. We are now at our regular agenda, and there has been a revision to the attachment with respect to the county manager's matter, which is up next, agenda item number 36.
And Chairwoman and Board, Deputy Attorney Debbie Blair is going to do that agenda for us.
Okay, thank you. And if you can help talk us through the revision that's been made as well.
Yes.
Okay, thank you.
Again, Debbie Blair with the County Attorney's Office, and I'm presenting the service delivery strategy between Cobb and all of its cities, with the exception of Mableton. As has been mentioned, Mableton, as a new city, is still in its transition period and does not need to participate at this time until it comes out of that transition period in the service delivery strategy. As you're aware, the cities and the county have been working for quite a while trying to reach an agreement on the new service delivery strategy. And on July 17th and 18th, we participated in mediation, which resulted in the agreement that is under your consideration today. The proposed agreement is for a period of 10 years, beginning on November 1st, 2024. Regarding the couple of changes to the service delivery strategy agreement, there is going to be attached to this agreement. We had intended to attach a list of all of the IGAs that exist between the cities and the county for various services, but that got very, very cumbersome. So we have eliminated that, although the DCA, Department of Community Affairs forms that are required to be sent to DCA as part of this agreement will be attached to this document. I don't know if you're aware, but the cities are also, we just got this in the form that it is today, and we apologize, but that's why there's the need for a couple of these revisions. The cities are approving this same agreement. We had, I think, one or two yesterday, today, and there will be one tomorrow. Once those once the resolutions from each of the cities and the counties have been approved, we will then forward that with all of the DCAs and the agreements to, or all of the Form 2s to DCA for their consideration. It is not an approval process with DCA, but simply they go through and confirm that all of the cities that are required to participate, the county, have indeed signed on and approved this agreement properly. The second change in the service delivery agreement is in number 3. We had originally stated that only the county would take advantage of all revenue sources, and the cities wanted that changed so that they could also take advantage of all revenue sources. It really is a very minute detail because service delivery is really about how the county tax monies are spent and what services they provide countywide versus just in unincorporated areas. We are asking that the board approve the resolution as presented today and to also approve the service delivery strategy agreement and authorize the chairwoman to execute the resolution and the agreement in substantially similar form as presented today. Any questions?
Okay. I will move that we approve the agreement and adopt the resolution if they have been presented.
Second.
Is there any discussion from commissioners? I certainly want to make sure I thank everyone, our staff, our county attorney's office, our finance department, our county manager, our city representatives, their mayors, their city councils for the arduous efforts for us to get here today. We have acknowledged that we have been working together for decades as one county with now 7 cities. But we realize that this agreement is very important to ensure that the way that we're taxing our citizens is fair with respect to the services that we provide, particularly when there could potentially be a duplication of service. And I think for us to get here, there was some give and take on the interest of both sides. We were on polar ends when it came to what we each felt we were due, and I say each from a county perspective and from a city perspective. But I appreciate all of the work that was taken, and also specifically by these commissioners that are up here, to find a path forward that could meet the interest of all that were part of the mediation as best as we could. So again, thank you, and don't know if any other commissioners have anything else to add. Okay, not hearing any of their comments or questions, I'll call the question. And the motion carries 3-2 with Commissioners Burrow and Gamble in opposition.
Thank you.
All righty. We will now move on to the next regular matter on our agenda, and that pertains to ARPA.
Excuse me. Good morning, Madam Chairwoman, Commissioners, and County Manager. Property Management has one item this morning. Property Management would like to request the Board of Commissioners approve an appropriation of funds from funding received pursuant to the American Rescue Plan Act of 2021 in an amount not to exceed $864,607.13 to support economic development and assist those negatively affected by the economic impact of COVID-19. Authorize the corresponding budget transactions, and further authorize the chairwoman to execute the agreement and any other necessary documents for said purpose.
Thank you. Commissioner Sheffield.
So moved.
Second.
Is there any discussion?
Just thank you guys for catching this. Anytime you have a redevelopment of an aging property, it's not uncommon to find these type of issues. So I'm glad we're able to correct them and move on and stay on target with our open date. Thank you.
Thank you.
All right, we'll call the question. The motion carries 5-0. Thank you. Yes, sir.
Okay.
We are more than ready for you.
Good morning, Chairwoman, Commissioners, Madam County Manager. The second item under the ARPA tab is for the board to approve a contract with Deloitte Consulting for continued administrative assistance with our ARPA program. Back in 2021, the board signed our first contract with the consulting firm Deloitte. Since that time, they have led us through the process of determining how we would spend the money. Also, now they have led us through the process of soliciting proposals from nonprofits and from county staff on the actual amounts. Now they are leading us through the process of making sure that those funds will be spent by those nonprofits and county projects in an effort to claw back any funds that will not be spent, so the board can reallocate that by the end of this year. They have proven to be a very knowledgeable partner in this process for us, a process that there's absolutely no way we could have done in-house. They bring a team to the table that is full of knowledge of the federal process, of the compliance efforts, of the completeness of the applications, and they have really done us well with this process. Therefore, we ask the Board of Commissioners to approve a one-year contract with Deloitte Consulting in an amount not to exceed $2,749,992 for 2021 American Rescue Plan Act consulting services, authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents. And just as a point of clarification, all of this comes from ARPA proceeds and not from the general fund.
Thank you, appreciate that. So moved as presented.
Second.
Is there any discussion? Yes, Commissioner Burrow.
Thank you, and thank you, Jimmy. I would just like to say thank you to you and your staff, and how important this is to have an outside consultant with these federal dollars, because not only are we not experts in this field or equipped to do this, but the liability is on the county. So I understand the importance of this, and I normally do not vote for outside consultants when it's for other things. I haven't in the past, but this being ARPA and federal dollars and them screening everything and giving us reports on a regular basis with your office, I do support this.
Thank you.
As long as we're in the realm of the full contract to 2026.
Yes, ma'am.
Thank you, Commissioner. Are there any other comments or questions? Call the question. The vote carries 5-0.
Thank you.
Jimmy. We are now at our DOT regular tab.
Good morning, Chairwoman, Commissioners, County Manager Drew Essler with DOT. The department has 8 items for your consideration this morning. Our first item is to recommend the Board of Commissioners approve change orders final to contracts for various completed projects in the 2011 SPLOST Transportation Improvements Program Fund and the 2016 SPLOST Transportation Improvements Program Fund. A total savings to the projects in the amount of $364,156.22. Authorize the corresponding budget and accounting transactions, and further authorize the chairwoman to execute the necessary documents.
Okay, so moved.
Second.
Is there any additional discussion? Commissioner Burrow.
Thank you for the savings, especially with the sidewalk fund. And just to be sure that these will go back into the district that they came from.
That's correct for all of the sidewalk projects.
Thank you.
Okay, are there any other comments or questions? Call the question. The motion carries 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve supplemental agreement number 1 to the consultant services agreement with Southeastern Engineering Incorporated in an amount not to exceed $187,900 for engineering design of Holly Springs Road Corridor improvements, project number B2303. Authorize a corresponding budget transaction, and further authorize the chairwoman to execute the necessary documents.
Commissioner Richardson.
So moved.
Second.
Is there any discussion? Call the question. Oh, excuse me. Go ahead, Commissioner.
Thank you, Drew. We had a lot of community meetings and open houses with regard to this, and I think this solution is best for all. So I'm looking forward to the Holly Springs, Sandy Plains improvements and the addition at the Davis Roundabout, and Old Canton, Holly Springs from Old Canton up to Post Oak Tread. So thank you.
Thank you.
All right, we'll call the question. The motion carries 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve a construction agreement with Norfolk Southern Railway Company in the estimated amount of $153,112 for the construction phase of Old Floyd Road at Veterans Memorial Highway, project number X2329. Authorize a corresponding budget transaction, and further authorize the chairwoman to execute the necessary documents.
Commissioner Sheffield.
So moved.
Second.
Is there any discussion?
No, just a simple thank you, Drew. This one has been a long time coming, and we're getting closer and closer to the finish line.
Of course.
So thank you.
Thank you.
Yep. Any additional discussion? Call the question. The motion carries 5-0. Thank you.
Thank you. Our next item is to recommend the Board of Commissioners approve supplemental agreement number 1 to the contract with Glosson Enterprises LLC for Sewell Mill Road Sidewalk, project number X2731, to include Sewell Mill Road school zone improvements in an amount not to exceed $235,769.66. Project number B2805, approve a contract time extension through June 30, 2025, authorize a corresponding budget transaction, and further authorize the chairman to execute the necessary documents.
Commissioner Richardson.
So moved.
Second. Is there any additional discussion? Call the question. The motion carries 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve project number AR18, task order number 4 to the 2022 master task order contract with Kimley Horner and Associates Incorporated in an amount not to exceed $470,511 for Town Center Busby Park and Ride Transit-Oriented Development Study. Authorize a corresponding budget transaction and further authorize the chairman to execute the necessary documents.
Commissioner Burrow.
Motion to approve.
Second.
Second.
Is there any additional discussion? Call the question. The motion carries 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve a contract with Glosson Enterprises LLC in an amount not to exceed $446,477 for West Sandtown Road Sidewalk, Mud Creek. Project number B2741, authorize a corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Commissioner Sheffield.
So moved.
Second.
Is there any additional discussion? Call the question. The motion carries 5-0.
Thank you. Our next item is to recommend the Board of Commissioners ratify previous action by the county manager authorizing emergency drainage repairs on Coopers Creek Drive in response to a sinkhole, approve a contract with City of Matthews Contracting Incorporated in an amount not to exceed $1 million for said repairs. Project number B22140, authorize corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Commissioner Richardson.
So moved.
I'll second. Is there any discussion? Call the question. The motion carries 5-0.
Thank you. And our final item this morning is to recommend the Board of Commissioners approve submission of a request for traffic signal application to the Georgia Department of Transportation for the installation of a traffic signal on Veterans Memorial Highway at Buckner Road, project number B2575. Authorize the operation and maintenance responsibilities upon completion of installation, and further authorize the chairwoman to execute the necessary documents.
Commissioner Sheffield.
So moved.
Second.
Is there any discussion?
Now, just a huge thank you on this one. And Chair, you may recall when you were Commissioner, this intersection has just been a location of just a lot of tragedy and fatalities and accidents. So we're really glad to see this one go through.
Definitely.
Of course.
All right, is there any additional discussion? Call the question. The motion carries 5-0. Thank you so much, Drew.
Thank you.
All right, we are now at our Public Services tab, and we have our first matter under Parks.
Good morning, Chairwoman, Commissioners, Madam County Manager. We do have one item for consideration this morning. We asked the Board of Commissioners to ratify previous action by the County Manager authorizing emergency replacement of the bulkhead at the Mountain View Aquatic Center. The bulkhead was over 24 years old, and during movement of it to replaster and repaint the pool, it buckled, causing several pieces to snap, twist, and warp. Unfortunately, it was deemed beyond repair structurally and would not be deemed structurally safe even after repair. So we had to get something ordered pretty quick. We asked the BOC ratify the emergency action of the county manager authorizing emergency replacement of the bulkhead in an amount not to exceed $299,731. Authorize a purchase order with Paddock Aquatics, and further authorize the Procurement Services Director or Chairwoman to execute the necessary documents.
All right, Commissioner Burrow.
Yes, motion to approve.
I'll second. Is there any discussion? Commissioner Burrow.
Thank you, Michael. I know we toured out there, and it definitely is going to have to be replaced. Are we still on schedule for September 30th for opening back up, and then the bulkhead would be installed at a later date when that's ready?
Yes, ma'am. So we did lose about a week in all of the moving around. We still think we can make our October 1 deadline to open back up at Mountain View. We will not open back up with a bulkhead. We will probably be purchasing it. We're looking at about 16 weeks. And what we're anticipating is sometime in December we try to find a week that's about 4 or 5 days that we can shut down so we can actually install the bulkhead. But getting the bulkhead back pretty quick is pretty necessary due to the aquatic meets that we have at that facility.
Okay. And then I know that it's very well utilized with classes and students, swim teams and all. So I guess there are other options, or central aquatic, or?
We have figured out a way, and we've talked with all the swim teams and the high school teams and everything else. We figured out a way to at least get by without the bulkhead for a little while. We're going to do a little moving around, a little different practice types and things like that. But we've got a way to get through because, again, it's only about a 2-month period. We're really anticipating it really kicking back off probably early February. So we're trying to just get it done before that time.
Okay. Thank you.
Thank you.
All right, is there any additional discussion? Call the question. The motion carries 5-0. Thank you, Michael. And we also have our next matter by our Elections Division.
Good morning, Chairwoman, Commissioners, County Manager. I have one item before us for consideration to approve a fund balance appropriation in support of the acquisition of technology and equipment needed for the 2024 presidential election cycle. In preparation for a potentially record-breaking turnout presidential election, we must ensure that we have enough equipment, personnel, and support to execute the election to the best of our ability. Due to the increase in Cobb County's population, we are requesting an increase in election equipment to accommodate an additional satellite site for advanced in-person voting and to add more scanners to reduce wait times. With more equipment and more locations, we need more carriers or hubs to transport and set up that equipment. Additionally, with a severe increase in concern for election worker safety, we're requesting funds for a security guard for our office, as well as panic buttons for poll managers. To ensure that all registered voters in Cobb County have all the information they need on how, where, and when to vote in November, we're proposing a voter information mailer that would go to each registered voter household. Most of the other costs are associated with the steep increase in personnel needs that come with a presidential election, as well as the purchase of poll pad printers for all of our poll pads to severely reduce wait times. It is further requested that the approval of this appropriation also include authorization for the Financial Management Service Department Budget Division to make the necessary transfers from the approved designated contingency to the appropriate expenditure codes to process payments as needed.
All right, thank you. I will move that we approve this agenda item as it has been presented.
Second.
Is there any discussion or any comments or questions? Go ahead, Commissioner.
Good morning, Tate.
Morning.
Since this is specifically for the presidential election in November, which we've known about for years, why was it not part of the 2025 budget, which starts October 1?
Sure. So we submitted the budget, I think it was the second week I was in my job. And so in speaking with the finance department, in order to make sure that our budget shows an accurate depiction across all 4 years of an election cycle, we thought it was best to remove all of the one-time costs that are only associated with a presidential election into a contingency, as not to have this huge bump and offset our budget for the other 3 years of the cycle, as these are all one-time costs directly related to the need to run a presidential election.
But personnel isn't one-time cost. That's
This personnel
recurring.
is the additional temporary, seasonal, and poll workers that we have to bring in for a presidential election. The only personnel-related costs that are in here for permanent employees are tech-related packages.
So this doesn't include the special election for next year?
It does. So in the attachment of the spreadsheet, which I know is small, so I apologize for how it came out, the very last line item does give for special elections a line item there for $894,236.92, which is the cost that we put in for running a primary and a primary runoff. If we were to also have to do the general election outside of the budget, what has been budgeted, which is next June, then we would have that additional cost as well. If we don't have a runoff for the special election, we'll be able to save money there.
Okay, but on page 276 of our book, it just says for special elections, 156, 132, 92. Oh, and it's in each primary and general total.
Yes, I believe so. That may just be for the primary. I don't have my computer with me.
Okay, so, okay.
Commissioner Gambrill.
With Commissioner Burrell's question, it makes this agenda item even more confusing, because you're stating that this is needed for the presidential election, yet you're saying these individual totals are what it's going to cost to run the potential 4 special elections in the future. So is it really for the presidential election, or is this for the future elections?
So I'm looking at my attachment that's printed out a little bit bigger. That's not the one attached to the agenda, and so I apologize. I believe I sent it out to y'all in response to another question. Where I do have the last line item for special elections is listed at $624,531.68. That is for the primary and the primary runoff. That is the only item on there that is not directly related to the presidential election. And already being here today, I just thought it would be advantageous some time to go ahead and include that, as my board voted last night on the schedule for the proposed special elections. Since we know we're going to have them, we want to go ahead and start planning them. And part of that is having the budget so we know how to plan appropriately.
Right, and while I understand that, the way you've got this laid out, and again, as I was listening to explain to Commissioner Burrell, it's almost like you're spending, you know, I'm just going to go down to your first bold line, 861, 132, 92 for the first special election, and then you've got it subtotaled for 343, 667, 92 for the next one. So the way this agenda item is set up is confusing compared to your language. And then on a separate issue, one of the speakers brought up about an article. Did you do an interview for that?
I did.
Thank you.
Okay. Hey, thank you for talking us through this agenda item. And if you can just help us here with the bold matters here. This has special election here 4 times, but you said that is not just for an election that may occur outside the regular election next year, but that includes runoff elections associated with the...
Yes, so the item that I presented is in the
Presidential
contingency for 624,531.68. That's for a primary and a primary runoff. So that would be for both of those elections.
Okay. Yes, go ahead, Commissioner.
So should that, I guess the do-over, if you will, for next year is still part of the 24 election, and it's not, it says 2024, not 2025?
I think the one I'm looking at has 2025. I think I might have submitted an outdated where they were all under 2024, but after talking with the budget office, we did split up some to be 2025. If the board would prefer, we can always remove that portion of what's being presented today, and I'd be happy to present it at a later date so it's totally separate from this agenda item so there's no confusion.
That might help provide some clarity, Tate.
Absolutely, I'd be happy to do
address,
that.
Yeah, I don't see any
issues.
2025. Even
Okay.
the special elections are say 2024, but if they're a carryover from, because they're not going to be on the November ballot, to 2025, I think that should be noted.
Absolutely.
And I did watch most of the meeting yesterday online on TV 23. And it's my understanding that you are proceeding with Judge Hill's order with the state map for next year.
That is correct. Yes, my board voted to approve one schedule if we do not have a December runoff, and then a schedule if we do have a December runoff. So they approved dates for both scenarios.
Okay.
Thank you.
Yes, and for finance, can we just back that from this page that has those line items, so it just reflects those costs associated with 2024?
Yes, we can provide a new attachment. And just as clarification, I know we say 2024 in here. We're going to approve these because some of the expenses would take place in 2024. even though the presidential election will be in fiscal year 2025, it will still be calendar year 2024. So you're kind of in a weird area. So all of these, if this was approved in totality, would roll, anything unspent would roll into 2020, fiscal year 2025.
And what is the label for that I see here, though?
So just looking at in the recommendation, everything says 2024. So some of those costs will begin to be spent in fiscal year 2024. But as we know, the presidential will be in November 2024 fiscal year.
Which should be between now and October 1,
That's
or
correct.
September 30th.
Yes.
Yes,
So-
is when our fiscal year is completed.
Yeah.
Okay.
So just a kind of a strange overlap between calendar year and fiscal year.
I need glasses that are a little bit stronger to see the label above that date, because it does not say date. What does that say on page 276? What is BFY?
So that's budget fiscal year.
Budget
So
fiscal year.
everything
So if
here
we
is
would have
listed-
seen that, then that would have provided some clarity.
That's correct. So everything listed here is for budget fiscal year 2024, which we're into today. So we're appropriating fund balance, loading this budget in there. Anything that is unspent for these purposes would roll to fiscal year 2025. The reason being is some of these expenses need to take place immediately.
Okay, then maybe we just delineate what's associated with the elections outside of the 2024 presidential election cycle, to Commissioner Gamble's point.
Yes, I think that's what I heard, is you would like us to break that out. Presidential only, special or additional elections in 2025, what those costs are.
Okay. We do have two additional questions. I'll go with Commissioner Burrow and then Commissioner Richardson.
And the impact to the 24 budget or 25 and 25 budget.
So this would be a one-time increase. So Tate did an excellent job, because we had to kind of walk through this as well. So we leave the budget flat for elections. So that every 4 years, we know there's a presidential. We ask them to come back with an agenda item as a one-time cost. So everything that's approved here, with the exception of a few security items, will not have any additional impact beyond this election. And I think the security items, we're looking at about 40 to 50,000 a year is what we're looking at. The rest of it would be simply one and done. There would be no future impact on an existing budget.
So it's all one-time money, fund balance.
Yes, we're asking for one-time money of fund balance appropriation. The only one that I can talk to that would have any reoccurring impact, and we'd work with elections on their future budget requests, is some of their security requests would have about a $50,000 impact going forward if we continue to utilize that product.
Okay, thank you.
You're welcome.
Commissioner Richardson.
Okay, and just to be clear, the approval, thank you. The approval would include all of the appropriations on this, but not this document that's attached. It would be replaced with whatever the updated view is for the 2024 expenditures and then the 2025 associated.
Yes, that's what I heard as well, is we would still be asking for the $2.4 million and change appropriation, and we'll provide you a detailed breakout of how much of that is for the presidential versus non-presidential.
Okay, thank you.
You're welcome.
Any other questions? We'll call the question. The matter passes 4-1 with Commissioner Gamble in opposition. Thank you, Tate.
Thank you all.
I know this is a busy time. We will now move on to the Support Services tab. And I believe we have one matter under Information Technology Services.
Good morning again, Chairwoman, Commissioners, and County Manager. Our item this morning is a joint item with the Sheriff's Office and Property Management to request the Board of Commissioners approve Phase 1 of a two-part design construction contract with CML Security LLC to include pre-construction and security electronics technology design at the Cobb County Adult Detention Center and the Judicial Complex facilities, in an amount not to exceed $991,666.66, 2016 SPLOST Project Facilities Improvements Program X0920, authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Okay, so moved.
Second.
Is there any discussion? Call the question. The motion carries 5-0. Thank you, Kimberly. And I believe that takes us to our second public comment.
We have no speakers for the second portion.
All right, thank you. That takes us next to the Appointments tab. And Commissioners, per our discussion, I did speak with the solicitor, and we will pull agenda item number 50. And that takes us to agenda item number 51. And that is, I move that we approve Ken Oman to the Recreation Board to replace Tina Garber.
Second.
All right, is there any additional discussion? Call the question. Thank you. The motion carries 5-0, and we are now at the Commissioner's public address, and we'll begin with Commissioner Gamble once the slides come up.
Our second annual Battle of the Paddles, also known as the Mixed Doubles Pickleball Tournament, will take place from 1 to 5 p.m. on Friday, August 30th at Jim R. Miller Park and Event Center. Different county departments will compete against other this year. This competition aims to raise money for Cobb Senior Services Meals on Wheels program. You can donate to your favorite department to help them win by scanning the QR code provided. We encourage everyone to come out and show their support. And second, congratulations to the 9 Cobb 4-H delegates who represented Cobb at the State 4-H Public Speaking Contest. 3 of them earned first place in the state. Keep up the excellent work. Thank you.
Awesome. We'll just keep with the flow. So from the office, got the 2024 Capstone Project Kickoff. What an amazing start to our 2024 Capstone internship. Last week we hosted the orientation and are thrilled to welcome this remarkable group of students who will spend a semester making a meaningful impact in our community. We still have a few spots available for the Smart Communities Report and the Arch Triangle programs. If you're interested in participating, please email us, megan.capetto@cobbcounty.org. During their program, students will gain hands-on experience while helping shape the future of Cobb County. We're so proud to support their professional journey and eager to see their innovative ideas come to life. A big thank you to all of our community partners. And thank you, Dr. McMorris, for the first session yesterday. And making this incredible opportunity possible. Learn more about our capstone internship programs at on d2cobb.com. And the quarterly report, it's that time of year again. Mark your calendars for our 2024 Q2 quarterly report. This is an opportunity to learn more about what's going on in District 2 and the rest. There will also be guest speakers and awards for active leaders in the community. The event will be held from 5 to 8 with a pre-community fair for resources if you want to come and learn more about the different services and opportunities around the county. And that will be in the Coward, in the auditorium of the Scouts of America, right across from the Battery. And then from the community, how to meet an author. Don't miss out on the opportunity to meet Kelly Stuckey, author of How to Teach a Troll to Read, at the Booked for Lunch event from noon to 2 p.m. Thursday, August 15th at Sewell Mill Library and Cultural Center in Marietta. Engage in enriching conversations and immerse yourself in the world of books and culture. Tickets are $30 each. And that concludes my comments. Thank you.
Thank you, Commissioner. We'll have Commissioner Burrow up next.
Thank you. Superior Court cases have been impacted by the new software issues. Last week, Chief Judge Gregory Poole of the Cobb Judicial Circuit declared a judicial emergency within the Superior Court of Cobb County due to serious issues in the Superior Court Clerk's office. The Superior Court remains open and conducting business. The judicial emergency only impacts specific deadlines and court procedures. And litigants with questions about the status of their case should get in touch with their attorney or the court to which the case is assigned. And importantly, this order does not impact the other Cobb courts, including state court, magistrate court, juvenile court, and probate. They are currently operating normally. For more information, you can go to cobbcounty.org/communications/news. Wreaths Across America, the Cobb Veterans Memorial Foundation will be celebrating National Wreaths Across America Day on December 14th. The group's mission is to adorn each veteran's grave in the Marietta National Cemetery with a wreath. And your help is needed. Please consider honoring our heroes by sponsoring a wreath. To donate, visit wreathsacrossamerica.org, and a portion of the sponsored wreaths will go towards building the new Cobb Veterans Memorial Park. And then, as you heard earlier, we have a couple of closures in District 3. The Mountain View Aquatic Center is undergoing renovations now through the end of September, and it is expected to open back October 1st. And also the playground at Mabry Park will be closed August 12th through the 16th as new pieces of equipment are installed, weather permitting. The work should be completed on August 16th. Thank you.
All right, thanks, Commissioner. We'll now go to Commissioner Sheffield.
Thank you, Chair. News and updates from District 4. On Monday, August 19th, the Cobb County School District will reserve a Digital Learning Day. Inspire your kids to embark on a day of outdoor discovery and fun. The event is open to children aged 3 to 11 years and will occur from 9 a.m. to 3 p.m. Remember to pack your child a lunch, snack, and water bottle. Our Giving Garden is located at 79 Cooper Lake Road in Mableton. For more information, please email camps@ourgivinggarden.org. The Cobb County International Festival is back and better. The festival will be held Saturday, August 24th from 11 a.m. to 4 p.m. This event offers a rich tapestry of experiences, including local and international music and art, eclectic dancing, delicious culinary options, imaginative crafts, beautiful jewelry, and a kids' corner, and many other vendors. Free parking and admission will make this a perfect day for the whole family, with activities taking place both indoors and outdoors. Jim Miller Park is located at 2245 Callaway Road in Marietta. Join the Cobb Police Athletic League for an exciting soccer camp open to participants aged 5 to 15. This camp will teach basic skills, techniques, and good sportsmanship. Camp will be held on Tuesday and Wednesday, September 10th and 11th from 6:30 to 8:30 p.m. at Traymore Park. The park is located at 2150 East-West Connector in Austell. Don't miss this opportunity for your child or children to learn and have fun with fellow soccer enthusiasts. Visit cobbcounty.org/police for more information. Thank you.
Thank you, Commissioner. I want to thank all of you for joining us today. We do have 3 community development hearings, which will follow today's regular portion of this meeting. Commissioners, I would ask that we adjourn until, would you like a 15-minute break until 11 before we get started with our first hearing? For those who are members of the public, you're free to stay here and observe these hearings, but we'll go ahead and take a break again until 11 a.m. and then we'll come back for our first hearing. Thank you. so much going on. Inquiring minds want to know. Good. All right, welcome back to our Board of Commissioners meeting this August 13th of 2024. We do have 3 hearings on our agenda, and I'm going to turn things over to our county attorney to help us walk through what's going to take place next.
Thank you, Chairwoman. I was out there, I was looking in the audience for Mr. Hensley. I was like, well, I don't know where Sam went. Now I see him at the podium. So, so if we'll move over. First off, we're going to address item 53, which is top massage, and Mr. Hensley give the latest update regarding that one.
Thank you, Mr. County Attorney. Good morning, Madam Chairwoman, Commissioners, Madam County Manager. I am Sam Hensley Jr. for the record, and as the County Attorney indicated, we are here scheduled for a due cause hearing on the health spa license for Top Massage, LLC, doing business as Top Massage at 2200 Roswell Road, Suite 150, Marietta, Georgia, 30068, Shamel Wang, licensee, and Ji Han, owner. I've been in contact with Mr. Michael Familetti, who is the attorney for the establishment, who is been called into court in another jurisdiction with trials today. By law, that puts us at a disadvantage in that takes precedence over an administrative hearing. So, Mr. Familetti has asked on behalf of his client that this board grant a continuance to hear this matter at the next convenient time that would be determined by staff and by the licensee. I will mention that in my discussions with Mr. Familetti, the granting of a continuance would be conditioned on this business staying closed until such time as that hearing can be held. So I have it in writing from him on behalf of his client that will be the case. So that would be the request from our office, that there be a continuance granted in this matter regarding Top Massage.
Okay, thank you. I'll turn things over to the District Commissioner.
I am certainly appreciative of the contingency on that and can definitely be okay with the continuance given the circumstances as well.
All right, so I'll move that we continue this matter to our next scheduled meeting, which would be...
Well, actually, I think the preference would be for the next convenient time so that it could be scheduled. So hopefully we can find a date, since it's going to be remaining closed, we can find a date that we know they'll be able to work.
So to a date to be determined?
Yes.
Okay.
Yes. We're hopeful that we won't have to go through this again with another conflict, so
okay,
that would be appreciated.
Second.
All right. Yes, any discussion?
Just that it has to be a morning meeting.
Yes.
Okay, any additional discussion? Call the question. The motion carries 5-0. Okay, and
the next one would be,
the same
I'm sorry,
thing?
item 54.
That's okay, Bill.
Yes, if Mr. Hensley, if you get an update for that one.
And that's V Massage, correct, Mr. County Attorney? So again, for the record, I'm Sam Hensley Jr. here for the Business License Division, Madam Chairwoman.
Mm-hmm.
This would be an appeal of a denial of an application for a renewal of a health spa license for Ru Yi Healing Spa, LLC, doing business as V Massage, located at 2800 Canton Road, Suite 1200, Marietta, Georgia, 30066, Ruan Zhu licensee. We face a conflict problem in this case as well, Madam Chairwoman, in that Mr. Ming Lim, who is the attorney for the licensee, is in a criminal trial in Gwinnett County as we speak. He was called into that. He did let us know that this was a possibility. He communicated with me yesterday several times. He was in the court awaiting a decision by the judge as to when his jury trial would be called, and it was called for today. So unfortunately, we have a conflict that we can't avoid in that case, and we would need a continuance by this board for that as well.
Thank you. I'll turn things over to the District Commissioner.
Yes. Did they agree to close until the hearing?
They did not. There was a visit by the Business License Division to this establishment on Friday. 3 more citations were issued to this establishment. There was indication from the licensee, whoever was on site, that the business would not continue, but that was not confirmed by Mr. Lim. In fact, he indicated to me that they do want a hearing in this matter. But again, from a process standpoint, our hands are tied when there is a conflict notice sent out, and it is a criminal trial in this case, but any kind of trial in Superior Court is going to take precedence over an administrative hearing, unfortunately. So that was the communication from the Business License Division and from the attorney for the licensee.
And they were cited again
That is
Friday?
correct. Yes, they had 3 more citations that were issued.
3 more violations?
Yes.
And we can't do anything about that?
Well,
Till they have a hearing?
all that can be done is to continue to police the problem, and that apparently is being done.
Okay, well,
I share your frustration.
be sure that we continue to inspect there, and also those violations need to be reflected when we do have the hearing, that they're continually violating code and during the process, and how many continuances do they get? I know federal court takes precedent over our local or even state, but
Correct.
I mean, that's also a way for them to continue to operate.
Exactly. And as Mr. Rowling said, the motion should be in the form of the next convenient meeting that we can establish with the licensee and the attorney and our people for that very reason. So we're going to work very hard to make sure this doesn't happen again either. But unfortunately, these situations do arise when our hands are tied legally as far as holding a hearing.
Okay, can you ask if any other commissioners have questions for him?
Yes, do any other commissioners have questions?
I do, and just for clarity, because if I remember correctly, we were scheduled to hear this case last month.
July the 9th.
July
Yes.
9th, thank you. And it got to be the end of the day, and he asked for continuance because he had to pick up his children, which is technically not a reason to grant a continuance.
The other issue, Madam Commissioner, was that there was an interpreter present
That also left.
who spoke Mandarin, and the interpreter had to leave at 5 o'clock. So we were without childcare for the attorney as well as an interpreter. So there was an additional complication with that. But you're correct. This was continued from that date as well.
Okay, I would like that for the record, because I think that, again, it shows a pattern here
Yes,
for
ma'am.
this applicant.
So, Mr. Hensley, can I make a motion to continue this to the September 10th BOC meeting?
Well, the only issue with that is we want to make sure that the licensee and the licensee's attorney is going to be here on that date. And we have not communicated a specific date yet for the resumption of this hearing. So my request would be that we...
And an interpreter.
Correct. We want to use the vernacular, have all our ducks in a row ready to go the next time we convene on this matter.
But Commissioner, that would be our effort to be able to make that happen on that date, and that
Right.
would be the first priority date, so.
Well, they can always ask for a continuance again if they get called to federal court or whatever. But I want us, the next available date that we can do this is our September 10th meeting. So I would use that date to start with to get them in here as soon as possible, because it's already been continued twice now, and they continue to operate.
Yes, ma'am, that is correct.
Okay, so my motion would be to continue the massage, item number 54, till the September 10th BOC meeting, if all parties are available and in agreement. Is that all right?
I'll second. Excuse me. I'll second for purposes of discussion. I know Commissioner Sheffield's still.
I wanted to ask if you can share with us what those additional violations were?
Yes, ma'am. And Ms. Webb is here if you'd like to hear from her as a representative of her
Would
office.
that be okay, or we can't?
do
It's too far, okay, no, that's fine. I can talk to her offline.
And those violations need to go through the License Review Board process, need to go all the way
I
through
was
before they
just
would come
curious,
before
I
the
should have
board.
asked before the motion, but I can connect with her offline, thank you.
All right, we have a motion and a second. Is there any additional discussion? Call the question. The motion carries 5-0. Thank you.
Thank you.
I believe that now takes us to the one hearing that we will be able to hear today.
Correct, which is
Okay.
item number 52.
Yes.
Item 52.
Thank you again, Madam Chairwoman. For the record, I am Sam Hensley Jr., the attorney for the Cobb County Business License Division. We are here today on a hearing of an appeal of the License Review Board granting of an alcohol license for Cobb Quick Mart, doing business as Cobb Quick Mart at 455 Pat Mill Road, Southwest Marietta, Georgia, 30060, Bhavesh Shah, licensee. This matter came before the License Review Board on May 16th, 2024, at which time the LRB heard the evidence and voted unanimously to grant the evidence, grant the license that was sought in that matter. There was an administrative denial of this application due to a distance violation under Cobb Alcohol Section 6-124, which requires that there be a greater than 300-foot radius from the entryway to the proposed establishment licensed to sell alcohol and the property line of the nearest residence. As a reminder, there are certain criteria under this code section that must be addressed in order for a waiver to be granted of that requirement. Those criteria are that the property values of the residents or residences would not be affected, that the quiet enjoyment of the premises by the residents thereof should not be adversely affected, and that the grant of such license would have no other adverse effect on the residents, again, if that license were granted. Again, the License Review Board heard testimony in regard to that and granted the license. That matter was then pulled from a consent agenda by this board for a full hearing in front of the board. So we are here today to present the basis of that denial. And the licensee is represented by Mr. Parks Huff, who may also wish to make a brief opening statement. And at that point, with your permission, I will swear in all the witnesses and call my witness.
Okay, thank you.
Good morning. For the record, my name is Parks Huff, of the law firm of Sams, Larkin & Huff. And to begin with, I'd like to thank the board for having the wisdom to have zoning separate from your regular agenda. And having sat here today, I'm just glad that y'all have it separate. So y'all rarely get anyone thanking you for something, so I thought it'd be a good change of pace to thank y'all for this.
Put it in the pocket.
But this is an alcohol license hearing. This is a case of a convenience store as part of a shopping center on Pat Mill Road. It actually was granted a license in 2020, but never opened in 2020. We have to remember what happened in 2020, and that affected this business. And so it was not able to open, and otherwise it would have probably been opened, for the last 4 years. They're ready to now open, and the alcohol license hearing came before the License Review Board. It has not been any objections by the community or any other involved parties, and the License Review Board recommended or granted the license unanimously. And so I know the commissioner has some questions and concerns, and I hope we address those, because I think my client wants to be a good member of the neighborhood, and will do a good job. I actually like these hearings because he's listening to the concern about alcohol, because his primary number one job is to make sure underage people don't get alcohol. So it's a great opportunity for him to understand the importance of it, so that these hearings do that. So we ask that you, after you hear the evidence, find that in fact this is part of a commercial area, will not negatively impact the neighborhood, as the License Review Board also found. So appreciate it, and look forward to the hearing. Thank you.
Thank you.
At this time, Madam Chairwoman, with your leave, I will swear in all the witnesses. If you're going to be testifying in this hearing or believe you may be testifying, would you please stand and raise your right hand? Do you swear or affirm the testimony you're about to give before this proceeding shall be the truth, the whole truth, and nothing but the truth? If so, say, I do. Thank you. You may be seated. I'd like to call Alicia Webb.
Good morning.
Good morning. Could you state your full name for the record, please?
Alicia Webb, Cobb County Business License Division Manager.
Okay. And what are your duties as the manager of the Cobb County Business License Division?
We collect occupation tax and we regulate businesses such as alcohol and health spa establishments.
And how long have you been a manager or the manager of that division?
5 years.
And how and where were you employed prior to that?
I've been in business license for 18 years.
Okay. And are you familiar with the Cobb Quick Mart that is the subject of this hearing today?
Yes, sir.
And how are you familiar with that establishment?
This application was submitted for a convenience store with beer, wine, and Sunday sales. It went before the License Review Board in May, recommended that the distance waiver be granted, and then the district commissioner asked for a hearing to be held on this.
So your office initially denied the application, is that correct?
Yes, in April.
Okay. And tell us what the requirements of the relevant provision of the Cobb Alcohol Code are.
So this application was denied based on 6-124 of the county code, as the proposed entrance is less than 300 feet from a residence. There's also within 300 feet and within 600 feet of the proposed entrance of the establishment, there is the property line of the Marietta Academy School. Those were the two grounds for denial.
Very good. And I'm going to hand you, with the permission from Mr. Parks, a certified copy of Section 6-124 to put into the record. Can you verify that that is a true and correct copy of that code section?
Yes, sir.
Madam Chair, I would like to offer that certified copy into the record. Were there any other disqualifiers that would have prevented the proposed licensee from obtaining an alcohol license in this matter?
No, sir.
Just the distance to the residence, is that correct?
Yes.
Okay. Are there any other establishments in the immediate area that are licensed to sell alcohol?
There are other establishments in the general area. So the closest is Mercado, and they have a beer, wine, and Sunday sales package license. That is at 2097 Allstill Road. There is also, within a half-mile radius, a Speedy Mart at 2270, the Chevron Food Mart at 375 Pat Mill Road, and then the Favor Market, which is at 2090 Favor Road. Those are the closest alcohol establishments to this proposed location.
And are those all convenience stores?
Yes.
And did any of those establishments, to your recollection, require a distance waiver in order to sell alcohol?
I do not recall the hearings on any of these. However, if those the distance requirements are obviously still there. So if they did not meet those requirements, we would have had to come before the board for a distance waiver.
Madam Chairwoman, that's all the questions I have for this witness.
Yes, thank you.
The Business License Division does a background check through the police department on the licensee, is that correct?
Yes, sir.
And you identify any issues with the licensee that would be objectionable, and in this case, there was no issue with the licensee to be a qualified alcohol license holder in Cobb County, is that correct?
Correct.
And you also have other list of criteria that you review, whether there's crime in the area, whether there's too many people hanging out, things like that, and your office can deny an application for those reasons. In this case, you did not deny it for any other reasons. Is that correct?
Correct.
And you also often receive input from the community, be it objection letters or emails and such, that can lead to either a denial or a hearing. In this case, you did not receive any objections from the community via email or letter. Is that correct?
We did not receive any opposition on this application.
Okay. In the License Review Board hearing, no one showed up in objection to the hearing, to the application?
No, sir, there was no opposition at the hearing.
Okay. And the License Review Board unanimously granted the application?
Yes, sir.
Okay, thank you.
Okay, we'll open up for questions from commissioners.
Let me start. Alicia, just a couple of questions. You mentioned that the other convenience stores received a distance waiver, but you also mentioned that you were not sure.
If those distances are not met in the cases of these stores, some of these stores have been there quite some time, so if they were granted a distance waiver, I wasn't part of the hearing. However, the distance requirements have been in the code since like 1992, even more so, probably 77. But if there were distance issues, they would have had to have gone through this process.
Right, but we don't know that there were, because I believe with this one, it's the residences, so I don't know if the residences were there before the convenience stores, or if the convenience stores were there first, because if it is the latter, then obviously a distance requirement waiver would not be required.
I can find out if you want me to find out when and how long they've been open. I think
Okay.
most of these have been operating for quite some time.
Okay, so it's very possible that the residences came after the
Yes,
convenience.
it's a possibility, yes.
Also, you mentioned that you did not receive any opposition to the application. Did you receive any support of the application?
I didn't receive any opposition or any support.
Okay. So on the map, and Brad, I'm not sure if you can show that for. Can you point to us on the map where the school is located, or perhaps maybe this would be for the applicant or for one of the attorneys, where the school is located in relation to the gas station and the residences that did not meet the distance requirement?
So I am not looking at that map. I'm looking at the alcohol survey that's included in the packet. It looks like this. It gives us the distance measurements. So I'm looking
Alicia,
at.
that's on page 376 in your agenda.
Pardon? What was that?
That's on page 376 in your agendas.
Yeah, we have it, but I just wanted the audience. Okay. Thank you.
Yeah, this map I don't have in my packet.
Okay. All right. Well, it appears based on the survey that property 429, 401, and 409, those three residences are, does not meet the distance requirement. Is it your understanding that there are at least three?
Yes.
Okay, because in your report or somewhere in here, I saw that there were multiple residences that did not meet that requirement. And also for the daycare or the school, which you referenced it as Marietta, let's see. Marietta Academy School. And based on the image that we're looking at, that's on the upper right, labeled 444 as the address. Now, in past hearings, it's been noted that daycares are not considered schools. Can you talk to us a little bit about that? And if in fact this is a school or a daycare?
This is a daycare.
Okay.
It is not a Cobb County school. However, they do teach the curriculum commonly taught in the school system, and there is a pre-K program at this daycare.
Okay, so my understanding is, although it's labeled as a daycare, if there is a curriculum, a structured curriculum that is taught, it would still be considered a school.
We would consider it a school.
So for purposes of this application, this would be considered a school and not a daycare?
Yes.
Okay. And this school falls short by, I think, close to 200 feet short So the school is basically 400 feet away, and the residences are 150 feet away. So there are two categories in which the distance requirements have not been met. Is that your understanding?
The distance to the residence and the school, correct?
Okay, thank you. That's all I have for her.
Okay, Commissioner Burrow?
So on the map that's on the screen, the GIS map,
Yes, ma'am.
this is located where it says BP in the red box. So 429 to the right is a residence that's less than 300 feet away? Is that
Yes,
correct?
according to the surveyor, the closest residence is 429 Pat Mill Road.
Okay, and what is 495 to the left of that? Is that a business or
Yeah, that's GC.
a daycare? I mean, not a daycare, but the daycare's across the street, up across Pat Mill. I see that at 444. And is 406 below the BP square? Is that a residence?
I don't believe so. I think most of that area right there in that little pocket is commercial,
Okay.
I think.
But to the right where 429, we know that's a residence that doesn't meet the 300 feet. Below that, 401, is that, can you give us the residents that do not meet the 300 feet requirement besides 429? Because
Back to the survey, there's the 3 in the circle, which is 429 directly behind the next R20, and then there's one below it, looking in the survey, from the alcohol survey. And the smaller circle, the 300-foot radius, it hits that, the nearest one being in that corner is R20. The parcel
okay.
directly behind it is R20, and then below it is R20.
Okay.
So it hits all 3 of those property lines.
Okay, so there's 3 residential that don't meet the distance. Thank you, Alicia.
You're welcome.
Commissioner Gambrill?
Just comments, because I know Commissioner Sheffield was wanting to know when the residents were built. So the home that is at 429 was built in 1958. 425 was also built in 1958, and then 401 was built in 1960. The shopping center was constructed in 1970, and that all came from the tax assessor's website.
Thank you. Are there any other questions?
Just a follow-up, Alicia, you mentioned when the alcohol distance was adopted, and can you repeat that year for us?
I believe it's 1977.
1977.
And I can double check that for you, but the
Okay.
ordinance, to make sure those are the distance requirements back that far.
So that was 1977, so anything prior to that is basically grandfathered. Okay, thanks.
Okay, are there any other questions? All right, thank you, Alicia.
You're welcome.
Oh, okay.
I have no other witnesses, Madam Chairwoman.
Okay, thank you. You may go ahead, whenever you're ready.
Good morning, and the questions actually help me because I'm going to try to answer some of those questions and state my place as the attorney, but also very familiar with the area, having handled the zonings in the area and for this property and adjacent properties. So I hope I address some of your questions in this short presentation, and then I'll have my client come up. So this is the subject property. This is the land use plan, and I have this intentionally because this is the long-term vision of how you expect properties to be used in the future. And you can see this is neighborhood activity center. So even the residential properties that are there are anticipated to be commercial in the future. That's your land use plan. The BP is a 15,000 square foot shopping center. My client acquired the shopping center with the idea of reinvigorating it. He's got 6 different tenants that are expected to come in there. One of those tenants is a convenience store with proposed beer and wine sales and the fueling pumps that have been added out front. And that is important because the shopping center has languished for a long period of time. It needs some energy and some people coming to it. And the tenants that he's got lined up, there's a ice cream place, a barber shop, a restaurant. Number one, they live in the area, but they also anticipate this use as being something to drive customers to the area. The other zonings, as you were talking about, the 444, I don't know if I can. The daycare is right here for your reference. It is of note that it actually shares a curb cut with the Family Dollar that's on Austell Road. This is the other alcohol establishment that was mentioned. There's also a Welcome Foods that is located right here, which is a convenience store with alcohol sales. So the land use plan is here. This is the zoning map showing that the zonings are kind of a hodgepodge. This was actually rezoned CRC that rezoning was done to allow the addition of the fueling positions to allow the investment in the shopping center. This is the shopping center as it sits today. The fueling positions were added out front. And again, it's one of multiple tenants in this shopping center, but a critical part of that shopping center revitalization is having a good tenant in there that draws customers. And alcohol is not a huge part of their sales, but if you can't compete with your competitors with a product, that's a challenge for a business. In 2020, this is the business license. Mr. Shaw is sitting here, acquired a business license in 2020, and he was very optimistic at the beginning of 2020 that he would have this shopping center remodeled and reinvigorated, and then COVID happened. And then as other unfortunate things happened, the contractor that was doing the redevelopment, putting in the fueling positions, went bankrupt. And that got turned into a bankruptcy dispute that took a couple of years before the property could come out of it. So he did have a license in 2020, anticipated to be able to open back then. Unfortunately, things got in the way, so we are here before you today. And I have also wanted to hand out to you that's 5 for the commissioners, 1 for the clerk. My client went to the surrounding residential properties that were in the distance waiver, and they signed stating that they did not have an objection to the alcohol establishment. They recognize the area is very commercialized. Their properties, if they're not already kind of used commercially, are anticipated to become commercial at some point in the future. And they want the shopping center. It's there. They want it to be successful. Having a business, someone investing in it is important for that. So they have submitted this. He did talk to the daycare owner across the street, operator, let them know about the proposal. They did not object, but they did not feel comfortable signing a statement of non-objection, but they did not have, they're aware of the hearing. They did not state they were opposed. They just weren't comfortable signing a statement that they were okay with it. So at this time, I'll ask my client to come up here. Can state your name for the record.
Good morning, Commissioners. This is Bhavesh Shah, the owner of the building, as well as I applied for the business and beer license.
Let me ask you some questions. So you applied back in 2020, is that correct?
Yeah.
And that was shown, you actually received the license, but unfortunately...
Yeah, after that, the COVID came, we couldn't get the equipment. All this material comes from a different country. So we need to wait when you do the order it takes like 6 to 8 months to deliver. But after the COVID, it was delayed. And we need to struggle to get the property because 18 months Mountain Express filed the Chapter 11 and after that Chapter 7 last year. And after that, we can able to start the work. We couldn't do any work for 2.5 years because the case was going on the federal government. So,
But in 2020, a license was issued, and a license review hearing like this was also had and granted the license. Is that correct?
sorry, sir.
You had a license in 2020 that was granted by Cobb County, correct?
Yeah.
And you were ready to move forward, just COVID got in the way and bankruptcy got in the way. Have you, tell the board what other tenants you have coming to the shopping center? What other tenants do you have?
Yeah, we have a local tenants, like one is a barber shop, one is ice cream parlor, one is Lolo's Cafe, the breakfast stuff in the morning, and one is a retail shop, the soccer retail shop. It's like a football and all the T-shirts, they are selling that. But out of 6, 2 businesses were open, and 4, like, we are waiting for the process to getting the business and business license.
They're waiting for you to open up the convenience store part of it. Is, how much money have you invested in this shopping center?
On the outside work only, you see the canopy pumps, underground tanks, it takes like $600,000. And to do fix the parking lot, like 35,000 square feet, that's 110,000. And the building cost itself more than $2 million.
And have you walked and talked to the neighbors?
Yes.
I
give the copies. I went to the whole street, like 6 houses over there, and they are excited, like that in near short term, I might be able to open the gas station over there.
Do you think that your business will have a negative impact on those properties?
No.
And you did talk to the daycare across the street, is that correct?
Yes.
They just were not comfortable signing a statement?
They are not signing because there is no legal documents to sign, but they don't have any objection. And like probably so many people, they knows me in the area because I have 3 other locations, and I keep the competitive gas price, like mine is always the cheaper one. And I keep the good brands like BP, Shell, and Chevron.
Do you have 3 other stores in Cobb County?
Yes, sir.
And
I
have you had
any
violations in any of your stores?
No violations since I started my first business in 2014, and there is no violation so far. Like I go as per the law.
I have no further questions.
Mr. Shaw, correct?
Yes, sir.
Just a couple of questions. What kind of procedures or protocols do you have in your stores to prevent underage or intoxicated people from purchasing alcohol?
First of all, every employee has to take the training from the legal agent. That's mandatory. And nowadays, all the register, like without scanning the birth date, you can't able to proceed the things. So they need to show the ID before to buy any tobacco or alcohol items. So we need to punch the birth date. After that, if it is processed, then you have to sell it. Like that's a driver license. Like generally people brings the driver license to show them.
So you have a point of sale system that also safeguards against that happening. And I believe you indicated or testified that you have not had any prior violations of the alcohol code in your other establishments. Is that correct?
Yeah.
What would be the consequence of an employee of yours selling alcohol to, for example, an underage buyer?
Means like without knowing me?
Would you continue to employ that individual?
No, I will fire him the same moment.
I have no further questions, Madam Chairman.
All right, commissioners, do you have any questions? Okay, Commissioner Sheffield.
Mr. Bunty, is it?
Bhavish.
Bavish, I'm sorry.
Yeah.
Did you speak with each of the, I guess, residents that signed these letters?
Yeah. Everyone knows me because from last 3 years, I'm going in this location probably in 3 times a week.
Okay. Okay, go ahead. Finish.
Yeah, so 3 times a week. So like people, they are walking nearby the complex and they know me by face, by name. So like it's very easy to understand that things.
Okay. Were you able to confirm, let's see how many signatures you have here. 3, 4, 5, 6, 7. 7 signatures, which by the way, I'm just receiving this just now, so just bear with me a little bit. But were you able to confirm if any or all of these are tenants or investors of the properties?
No, they are like living on the nearby street.
Right, okay, but you weren't able to confirm who were actually homeowners of the property or who were tenants. And the point that I'm getting at, you know, tenants, they come and go. So I was just curious if you were able to identify which were the actual property owners versus tenants.
I can do that. I can like ask them to write the house number.
No, I have the house number. I'm actually looking it up now. And the first gentleman appears to be the homeowner, but I got as far as looking up 3, Ms. Pratt, Ms. Hutchison, and Ms. Leonard appeared to all be tenants.
No, they are the homeowners over there.
Not according to our tax records, they're not.
Yeah, not all,
It's
yeah.
owned by an LLC, all of those properties, so those are not homeowners.
Yes, Commissioner, the property off of Lorraine Drive is a hotel motel.
Okay.
500 Lorraine Drive.
Backside
Hold on.
probably we have 2 motels. One is
Pardon?
Back of the property we have 2 motels.
Okay,
One is having 500 some rooms and one is having 110 or 105 rooms.
okay. Also, in 2020 is when you submitted your application for, your zoning application for this property?
2020?
Was it 2020?
Yeah, I got the license.
Okay, so in 2020, and I need to go back and look at that, the business license that was placed up a short while ago, but in 2020, when you submitted your application, were you aware that you would need to submit a separate alcohol license application?
No.
You were not aware that you would need to submit an alcohol license application?
We did the alcohol license on 2020.
Yeah, if I may
We got
clarify,
the
I remember
license.
the zoning of this because I remember when it was coming in for renovation, it was before 2020.
Okay.
So I perceive that the alcohol license may have gone through a similar process as
Yeah,
what we're.
If I could state
Yeah.
my place.
Please.
The zoning was handled in 2017.
Yes, because I remember dealing with a different owner at that time, or the applicant was somebody else, probably the one that went through the bankruptcy that was renovating. In fact, it looks a lot better than it did prior to then, but yes, this was subsequent to that.
And then,
yeah.
and then the alcohol license the application would have been in 2019.
Okay,
And it was, I mean, he got both a business, Mr. Shaw himself got both a business and alcohol license. That's what I showed on the board.
Can you put that back up for me, please, if you don't mind?
So that's 2020, for the year 2020 expires 12/31/2020. And the ALC 0020 405, if I can remember, yeah, 405, that indicates it was an alcohol license. It's not just a general business license. It was
Okay,
also
so
an
this was an alcohol license granted in 2020.
So he did everything fine there, then he got delayed and then had to refile again because it had been more than a
yes.
year.
I was
So-
going to say, yes, this, excuse me, Commissioner, for interjecting. This was issued the first, which makes me think, yeah, this was under consideration even before 2020.
Mhm.
Yeah.
Okay. All right, thank you. I'm done with my questions. Go ahead.
Yes, Commissioner.
These signatures and these addresses, which ones are under the 300 feet? Maybe whoever can answer that.
There's the two houses next to the building.
Can you put the GIS back up, Brad? Thank you. Okay, so 429 we know is the distance, doesn't meet the distance requirement. 500 Lorraine Drive is,
That's a GC property, that's not a residential.
oh, okay, so that's way down there, so that doesn't really apply. And 293 Pat Mill, where's 293 Pat Mill? Way over here, way over here. So they're way outside the distance. 1251 Waymar Court. I don't know which one is Waymar Court, but it's far away. And then 2151 Favor Road, that sounds like a business too, but I don't see Favor Road. So,
There's Favor Road right, but it's outside of this.
yeah, so 429 is one of the three that are, you know, don't meet the distance. But, Mr. Parks?
Yeah.
This is not zoning.
Correct.
I know you're trying to establish when this was zoned and when this was, and the alcohol license, but this isn't zoning, so the commercial around it, whether they have it or not, this is separate from zoning, and it's a privilege to have an alcohol license.
The point is that if you live in an area that's designated as commercial in the land use, because your decision is whether the alcohol license, not a convenience store, just the alcohol component of that convenience store negatively impacts the surrounding property owners. So it is relevant whether those are in an area that is designated as potential future commercial. Because if you're in an area that's all residential around you and no commercial, then it has a different impact. This is a commercial area with a hodgepodge of commercial zonings in a land use plan that anticipates it be commercial. That leads to the question of whether it has a negative impact on the surrounding properties. He went to his surrounding neighbors, asked them their opinion. They all said that they didn't think it negatively impacted them, and they supported it because they want that business to be successful. So it is relevant to that. I understand your point. It is not zoning, but it is relevant to your decision in evaluating this case.
Well, my concern, and what we're hearing today, is the distance requirement that it doesn't meet. So regardless of what's around it, or I'm just saying alcohol license is separate from zoning, and it needs to stay there.
Well, the board has a distance waiver process, and that process has been in place in pretty much most establishments on Dallas Highway, on Canton Road, on Johnson Ferry. They almost all have a distance issue because they're usually commercial on the front and residential behind. So this board looks at it holistically and makes a decision. So you have a process. It just because there's a distance problem should not be the end of the story. The rest of the story is in the context of what's around it. What do the neighbors think? Does it impact what's already there? That's important to know too. You have a shopping center that has not been functioning properly, that has not been successful there. So it would benefit from a successful business.
Commissioner Sheffield?
For the applicant, how many attempts did you make to speak with the residents at 401 and 409?
Probably sometimes they sit outside the home, like this is the summertime, so they sit. So they see me, I'm coming back regularly. So I just try to approach and they say, okay, they don't have to.
Okay, but I'm not finding a letter of support from either one of the owners of that property.
Sorry, ma'am, can you say one more time?
For the homeowners at 401 and 409, which did not meet the distance requirement, you just communicated that you had an opportunity to speak with them. Is that correct?
Yeah.
Okay. And when you spoke with them, what was their feedback?
They are very happy. They say it's very nearby. It's easy to them to get whatever they need. The gas station and the convenience store, both is like in a walking distance to them.
Okay. Then why do we not have a letter of support from the two that are mostly impacted? Instead, we have letters of support for properties that are quite a ways from the subject parcel and even from the properties that did not meet the distance requirement. So why didn't you get a letter of support is what I'm asking.
A few times I went on the other house, but they don't. They were probably on the job, so they didn't meet me in the daytime.
Okay, so, okay. All right, so I just want to go back to the plaza because I'm hearing that it won't negatively impact the community, but who's to say that it will or it won't, right? But the other thing is, am I hearing from you that if an alcohol license is not granted, that you will not be able to develop the plaza? Because it sounds like you have tenants that are ready to move in. So I'm just trying to figure out why would that be contingent on this license?
This is a business model like for the local people. If I put the competitive gas price, people comes, and nowadays people don't want to stop like 3-4 times before they go to the home in the evening. Once they fill the gas, they park the car outside, fill the gas, they come inside, they grab whatever they like in one stop. And if I don't have a certain things in my store, I cannot compete with my other neighborhood business people.
Right, well, I understand what you're describing is an impact to you, but that wasn't my question. My question is, are you communicating that you would not be able to develop this plaza and have tenants at this plaza without this waiver? Because you mentioned earlier, hold on, you mentioned earlier in your testimony that you had several businesses that were prepared to move into this plaza. So I'm trying to understand from you why they would not be able to move in if this waiver is not granted.
No. The two businesses already started. One is Lolo's Cafe, and second is Barbershop.
Okay.
The rest is the process like I apply the business and beer. They did the contract last month, a month before. So it takes 3 months to get the business license because there is so many things they need to develop before they get the business license.
Okay.
Like the ice cream parlor people, they just came to know that they need to change the tiles because of the slippery. So they are doing some changes in their business, to get the business license.
Okay. And just one other question, and I'll open it to my colleagues if they have any questions. Is it your plan to remove the existing structure or the fuel tanks or the fuel?
No, this is brand new station. They just completed 2 months ago, 1.5 months ago.
Okay.
So we installed the new tank, and we installed new canopy. There was no canopy earlier.
Okay.
And we installed the new pumps as well last month.
Okay. All right. Thank you. All right. Thanks. That's all I have for right now anyway.
Okay, are there any other questions? Okay, thank you, sir.
I believe Mr. Huff has no further witnesses. I would ask if these statements are going to be offered into evidence.
Yes.
Okay.
Tender those as evidence.
I have no objection to that, Madam Chairman. And I will reserve my closing till the end.
Okay.
Again, thank you for the time this morning. This is a situation where, he had the zoning done in 2017. He had his alcohol license in 2020. Unless you open in a year, that license has to come back through. So this county has already at one point made the determination that the license was appropriate and did not negatively impact the surrounding properties. That decision was already made in 2020 for that license to issue in 2020. I understand that you're not bound by that. I agree with that. You're not necessarily bound by that, but that decision was previously made. He unfortunately got caught up in initially COVID, but then the bankruptcy of the jobber held it up for 2 years before he couldn't get on the property to finish the development because of that. So now that he's ready to come forward, the critical point for him is these businesses work with each other, and it wasn't that they won't be there, it's they won't be as successful if the center part of that business that is not successful. Your question is only the alcohol component of the business. You're going to have a convenience store, one or the other. That convenience store is going to be selling gas, is going to be selling the other items that you typically see in convenience stores. The only question is whether the addition of beer to that, which is critical to his business, is functioning, has a negative impact. I don't think there's any evidence before you today that the alcohol component of that would negatively impact the surrounding properties. In fact, the only evidence you have, the only evidence before you is the letters from the neighbors in support of the application. You have no other evidence before you other than that. And the client's testimony that he's talked to the neighbors he's talked to want him to be there, want him to be successful. The neighborhood knew of the hearing. You have hearings all the time with opposition, so you know that people know how to oppose alcohol licenses if that is in their interest. So the fact that we didn't have any opposition is also evidence that you don't have any opposition. So the only evidence before this board is supporting of the distance waiver, which the License Review Board heard and granted unanimously. We ask that you also follow what you've empowered your License Review Board to do, respect their decision in a case like this with no public opposition, that they made the correct decision. Thank you.
Okay. Thank you.
Madam Chair, just as a point of clarification too, apparently there was a little bit of confusion, and partly on my part as well, as to whether this Marietta Academy daycare qualifies as a school under Georgia law. And I think the confusion arose from the fact that on the survey plat that was included in the application packet, it is indicated as a daycare. However, we've heard testimony from my own witness that we have confirmed that does teach a Georgia pre-K level curriculum, which would make it a school under our code. And I mentioned at the beginning what the criteria are for granting a waiver in 6-124 for a distance violation to a residence. I also need to make sure that I mention the requirements under 6-125, which requires a 600-foot distance from church, parks, schools, or libraries. And that is that there would be a showing, I'm going to read this verbatim, if satisfactory evidence shall be produced before the Board of Commissioners that no adverse effect to property values or the use of the facilities for the purposes aforesaid would occur if a license was granted. And the operative word is may grant a license. It is not mandatory, as you know, and that applies to both 6-124 and 6-125. So just clarifying what the criteria is in our alcohol code for the granting of a waiver of these distance requirements. Beyond that, Madam Chair, I would just leave this decision in the good judgment of this board based on the testimony that's been presented today. Thank you.
Thank you. With that, I'll turn things over to the district commissioners.
Thank you for joining us today and all the testimony, and also for the clarification on the school versus daycare. I understand that this was an application that was brought before the board or decided before the License Review Board in 2020. I'm not sure if at that time it went before the Board of Commissioners or if it just passed through the License Review Board in 2020, but unfortunately that license also expired in 2020. While I can appreciate the future land use, the observations of the future land use, what's before us today are the distance requirements, and that's what we will focus, or at least I will focus my attention on. I appreciate the variety of businesses that you plan to bring to the community. I believe it was a barbershop and several others in the strip mall, and also the letters of support that you submitted to us this morning. Thank you so much for those. There were 7 letters of support, but just 1 letter that is from a person that would be directly impacted by the distance requirement. And just to reiterate, there are 3 homes that fell short of meeting that distance requirement, and also a school that also does not meet the distance requirement. I can appreciate also your wanting to be competitive with your business and having alcohol at the location. Obviously, that fits with your business model and being able to sell alcohol at this location. However, I am concerned that there are residences that are close by, directly across the street from this location, and even more concerned that there is a school that falls outside of the distance requirement. So, with that, I am not supportive of this request, and I'm not sure, Bill, if there is a particular way that I need to phrase this, since this is coming before us as a hearing.
Based upon what you just said, it'd be a motion to deny the waiver of the distance.
Okay, and I'm not sure if I need to make a motion before there are comments, if anybody has anything to add at this point, or anything, okay. So again, I really appreciate the investment in District 4, and while there may not have been any opposition here today, I'm also concerned that we did not receive letter of support from the 2 other properties that were impacted. I don't know if there was an effort to speak with the owners of the school, or even the parents who have students at the school. That was not mentioned today at all in your conversation and talking with the community. So again, with that, I make a motion to deny the application.
Second.
Okay, is there any further discussion? I'll just share, as a district commissioner, I do remember this zoning, and I remember the gas station being the argument for why it needed to be put there. It wasn't there initially. It was a rundown convenience store, and it was put forward to help improve the viability of the convenience store. And then, what's happened was a gas station comes in, then there's this request, but that was not shared at the time. I can't recall the request of this alcohol license, but it had to have come through the similar process that all alcohol licenses go through. I think it's unfortunate the timing is getting, the best of you here, but I know the interest of the board can change over time, and our district commissioner is very sensitive to the impact that this will have on the surrounding uses, particularly those that are inside that radius of consideration. So with that, I'm inclined to support your position, but I'm also sensitive to the impact that it's had just as a result of time. Okay, is there any additional discussion? We'll call the question. The motion carries 4-1 with Commissioner Gambrell in opposition. I believe that concludes our meeting for today. We are now adjourned.